The first case to come before the court this morning is City of Akron versus Kelly Taylor. Both sides are prepared, I assume, to argue?
Yes, sir.
Okay, each side will have 15 minutes, and the appellant may reserve up to 5. Please let me know, and I am watching the clock, and I'll try to let you know as well if you start going beyond that time period. Obviously, the monitor's over there. You've all been here before. The monitor's over there. You can look at that as well to see what your time is. Please, as you know, we record these and they are presented on YouTube. So please do not mention the names of any victims or mention the names of any minors. Stand behind the podium and keep your voice up. Please introduce yourself and who you represent, and we're ready to proceed. Just let me know how much time you want.
Thank you, Your Honor.
Mm-hmm.
Good morning, Your Honors. May it please the court. Joseph Schell from Summit Legal Defenders on behalf of the appellant, Mr. Kelly Taylor. Judge Carr, I'll reserve 2 minutes for rebuttal.
Thank you.
So what's clear from the record is that the trial court sentenced Mr. Taylor to 30 days in cask and suspended also a 30-day jail term. What's unclear from the record is why that happened. There are 2 options. Either he did it because the trial court thought that Mr. Taylor violated a term of his community control, or because the trial court thought that Mr. Taylor was in contempt of court. For either one of those reasons, though, is error, and the city concedes the first. So I'm going to focus my time here on the first assignment of error, on the community control violation, on 2 topics. So one, why this is a community control violation and not a contempt proceeding, and then secondly, what the rationale is for the court to reverse, because I think it's not covered explicitly by the city's concession on the first point. So there's 3 reasons why this is a community control violation instead of a contempt hearing. One, it was the hearing proceeded on a show cause order.
I do have a question about that. So in these specialty programs, some of them are diversionary and you plead guilty, but it's held in abeyance. This isn't that type of case. There was a finding of guilt and an actual sentence?
Correct.
Okay, I'm just making sure that's clear because then we'd be in a different territory altogether.
Yeah, that's right, Judge Lenziger. So in record page 21 is his original conviction from March of 2024, and it did sentence him to 12 months probation, 180 days in jail suspended with these Compass and Portage Path counseling requirements.
Okay, thank you.
Yeah, so because we're proceeding on a show cause order at this hearing, that's not a complaint. It's not a written complaint, which this court has required in both Alvarez and Hayes to proceed on an indirect criminal contempt charge, which this would have to be. Second, there are those kinds of complaints, though, in the record on other occasions. There were just never a hearing or a ruling on either one of them. So there was one in September of 2024 and another one in May of 2025, showing that the trial court at least knows, or at least seemingly knows, how to file a contempt charge if that's what it wants to proceed on.
And are those findings, I don't recall from the record, haven't had a couple of these. Are those the same kind of checkbox formula of show causes where the court has checked, didn't do this, didn't do this?
Yes, Judge
Type
Stevenson.
of file. We're not saying there's a specific, ever prepared a motion for complaint. It's always this form filing that the court uses called show cause and some kind of probation violation. It seems to me it's a little of a...
So the contempt complaints here are the same as we've been talking about in the City versus Donald Frum and City versus Neshemia Davis. They are those checkbox complaint forms. Both of them alleged that Mr. Taylor failed to appear on one specific date.
And we say both of them, that like an April and June one, or this December and April one for the June hearing, there was nothing new.
So there was a September 2024 contempt complaint that said that alleged that Mr. Taylor didn't appear allegedly on September 10th on September 11th for a court appearance. That appears to have been dismissed via a court order in October of that year, requiring Mr. Taylor to attend Compass sessions bi-weekly. There's not an explicit dealing with that contempt. It's not clear that that's the exact contempt charge, but it's the only one that it could be. Then there's another contempt complaint in May of 2025 in between the 2 show cause hearings, or in between the 2 show cause orders. And that one also alleged that Mr. Taylor failed to appear on one specific date. Again, that he wasn't scheduled to do anything there, though. There was never a hearing on either one of those contempt complaints. It does look, and there are 2 show cause orders then separately. There was one that was issued in April of 2025 There was a hearing scheduled on that for April 30th. It appears that never happened. There's no record of a hearing on April 30th. And then there's a June 26th show cause order that rolls in all of the allegations from the April show cause order, adds seemingly the failure to appear charge from the May contempt complaint, and then that hearing is held on July 2nd, and that's the order that gives rise to this particular appeal.
So to the extent this hearing is about anything, it's about a show cause hearing filed in June.
Correct.
Okay. I had that, I make sure I had that right when we started talking. There was nothing in writing this time, but I want to make sure.
That's right. Yes. Yes. So that's the second.
Could I interrupt? I
course.
guess I'm a little confused. Obviously, if the city or the state concedes error, we don't have to accept that because we don't want bad law,
Correct.
Obviously. But it seems like this is pretty straightforward, and they have. What are we actually here for today? What are you arguing for us to do other than what the city has conceded?
Yeah, so I don't take issue with the city's concession, right? As your Honor mentioned, because the court's not required to accept it, and because it's a little unclear whether this was, exactly what the finding was, because the trial court doesn't say, I find that you violated your community control conditions, or I find you guilty of contempt. I want to make sure that the court doesn't have any questions about, about exactly what the finding is here. And then secondly, though, I think the real meat of what I want to get at today is why the court should reverse, because there's two options for that, and I think neither one of them are clear from the city's concession, so let me jump into those.
Okay.
The first one is to say that the trial court erred in denying Mr. Taylor's post-judgment. It was titled a motion to vacate the judgment. I think it's the substance of it is a motion under Criminal Rule 34, a motion to arrest the judgment. Because that motion alleges that the trial court didn't have the authority or the jurisdiction to hold these community control violation hearing in the first place, and that's what Criminal Rule 34 gets at. So that's one way to I think to reverse, and the other is just for plain error. Is that because under State versus Rue, under the Supreme Court of Ohio's decision in that case, it is clear here that the trial court did not have jurisdiction to hear a community control violation because the proceedings were commenced after Mr. Taylor's community control period had already expired. So the first thing that could be getting at this community control violation was the April 2025 show cause order, and that's already 3 weeks after Mr. Taylor's community control expired on March 20th of 2025. So I think plain error is cleaner. One, it doesn't require the court to get into exactly what this post-judgment motion was. It can avoid this Rule 34 issue, right, and just say strictly from State versus Rue that there was no either authority or jurisdiction for the trial court to find that Mr. Taylor had violated community control conditions when those proceedings hadn't started before his community control term ended.
So if hypothetically speaking, if a defendant was on probation or community control,
Yeah.
and they didn't appear for something and there was a warrant issue, and then that goes past, they're missing, and that goes past the community control period, you couldn't bring that action any longer unless there's something, an actual formal proceeding commenced over the non-appearance?
That's right, unless, so there would have to be, in the meantime, a judicial finding that the person had absconded. That's one of the reasons under the statute that would toll community control, period, is that, right, either they had absconded or were in prison. So there has to be a judicial determination, though. That comes straight out of Rue in paragraph 20 and also paragraphs 31 through 37, where it says there's no automatic tolling without a judicial determination. And then since Rue, I'm sorry, go ahead.
Nothing.
Since Rue, the 3rd district is the only court that I could find that has addressed this situation specifically, both in Havron and Padgett. Those are both cited in our briefs. And those courts both say that the mere issuance of an arrest warrant without more doesn't toll community control per Rue. So those are the only things here that could have told time here, but there's no finding that on any of those things that would have told community control. I think even the city concedes that at most, even assuming right that tolling did occur here, which it can't under Rue, but even if it did, it only tolled for a couple weeks, and it's not enough to bring these, even the April 15th show cause order, the first one that within the appropriate time period to rule on a community control violation.
And why do you say plain error? It seemed to me the trial court proceeding without jurisdiction. It's just, I don't know if we have to recognize it's plain error, it's error, and the court didn't have jurisdiction, so we would reverse.
Fair enough, and I don't want to quibble too much with how it's categorized. I think this court has said before in Lang that a trial court exercise or exceeding its authority is plain error. There is, Rue says that this is a matter of authority. 2 years after Rue, the Supreme Court of Ohio in Brasher said that a trial court doing something about a sentence violation after the sentence is over means that the trial court didn't have authority to do that. Jurisdiction. So there's a little bit of tension there, whether it's strictly authority or whether it is a subject matter jurisdiction question. So I think you're right, though, Judge Stevenson. You could just say that it is error to act without authority. That's what the court said in Lang. That's what it can say here, because I think, again, given the city's concession, there's no question that these proceedings were not commenced within the proper time period. But unless the court has other questions, that's all I have. That's all I have for you today.
All right, thank you.
Thank you.
Good morning, you have 15 minutes.
Thank you, Your Honors. Good morning, and may it please the court. I'm Jacqueline Corgan on behalf of the appellee, the City of Akron, which, to be very clear, is conceding error in that the trial court in this case either lacked authority or, more importantly, lacked subject matter jurisdiction to issue an order that Mr. Taylor be in cask for 30 days. If without subject matter jurisdiction, the order is void. Without authority, it is at least voidable, and the city is conceding that it should be void. That it is voidable, and since we're conceding error, it should be held as void.
Your view would be that the court lacks jurisdiction, I take it from what you're saying, or you're not sure, as counsel for appellant, not entirely sure how we should say there's error, but you would agree there's error.
I'm saying that either way the court decides whether it's lack of subject matter jurisdiction or that it is a voidable order, we're saying that it is still wrong and therefore it is all void, no matter how you cut it. But let me make it very clear. I'm just here basically to answer some questions, but I would like to make a few points. The first one is that the city is not arguing for automatic self-executing community control tolling. That's not true. It does appear that we agree, me and honored counsel, that this was indeed a community control violation because you look at the substance of what happened and what the substance of the orders that were issued to Mr. Taylor and what has happened. This is a community control violation. It really should not have been a contempt proceeding. And because it was a community control violation, this court, the Ohio Supreme Court has already answered how to properly invoke community control tolling through unRU and then followed by the RU decision.
Isn't cask a community control sanction? Because cask is not jail, we've already established that.
That's correct, but
So if there's some told time and you have 30 days of cask, you're actually it's just 30 extra days of community control.
yes, but without the authority to issue that order, which is what the city is conceding, that order itself is either void or voidable. So, and we're arguing that it's void. And I mean, looking at how this happened, and even with arguable tolling, the trial court was beyond its authority to order Mr. Taylor into cask.
To modify the sentence.
Correct, to modify the terms of the community control. Right, because even in misdemeanor sentencing, community control is a potential sentence, and under the statutes that apply to misdemeanor community control, you can have that mix that we have here of suspension of a certain portion of jail time in lieu of following conditions for a certain period of time, up to 5 years. And then if there's a violation, the court can do what it is empowered to do, which is to extend community control, modify the terms of community control, or send the person to jail for the violation. But because the city is conceding error in the way that it is, that the trial court lacked authority to do what it did, or in the alternative, lacked subject matter jurisdiction to do what it did, that renders all the other arguments concerning how it's going to toll, burdens of proof, sufficiency of evidence, due process, those are all moot and they're not properly before this court. Any opinion this court would issue concerning any of those would be strictly advisory.
As opposing counsel said, with jurisdiction and subject matter jurisdiction and just that hybrid jurisdiction, there's that tension that the courts have engaged in over the years. With this particular case, though, you don't disagree that the court had subject matter jurisdiction over a community control violation.
And I think this is where we get into the fine points, okay? The court definitely had subject matter jurisdiction to set the terms of community control and to manage, for lack of a better term, the community control. For instance, during the period of community control, the court had the authority, had the subject matter jurisdiction to alter the terms of community control if there was a violation. However, there is a tension in the case law as to whether that subject matter jurisdiction ends with the termination of community control, either because it's expired or because the person has successfully completed it, or whether that continues. And I think that the Unruh decision, which was a writ of prohibition decision, illustrates that tension, because in that case, the person it was a felony case, but the person was on community control, violated the community control and absconded, went to Mexico. And what the court did in that case was sent him a letter indicating that it wanted him to appear in court to answer a charge that he had violated his community control. That happened prior to the expiration of his community control. Then what happened is he appeared in court and the hearing was continued to a date that fell beyond the expiration of his community control period. What he then did was he then filed a petition for a writ of prohibition to order Judge Unruh to cease the proceedings. The proceedings had begun prior to the expiration of his community control, but had been scheduled beyond it. He wanted that last step, which would have been the finding that he had indeed absconded and was going to be, that his community control would be violated on that basis. That was extended beyond the end of his community control period. What the Supreme Court said then was it was not patently and unambiguously clear that Judge Unruh lacked subject matter jurisdiction to do that. And that's where they held that so long as a court initiates the proceedings commence, okay, and there is notice to the defendant prior to the expiration of the community control period, that is what tolls the community control until the person appears in court again. Okay. So unfortunately, they didn't resolve the question clearly as to whether the trial court in the case we have at bar would have subject matter jurisdiction, but it said that Judge Unruh did not patently and unambiguously lack it. So that's where the tension arises.
Well, it's not only tension in this particular situation, it's tension with a lot of situations.
Right.
They're interchangeably used and it should not be, but regardless.
In your brief, you indicate that you're conceding that the court lacks subject matter jurisdiction. So that what you'd be asking us to make a decision on as far as the concession goes, lack of subject matter jurisdiction?
Yes. Yes. And to the extent that, the court has asked me questions about whether it's subject matter jurisdiction or whether it's void versus voidable, in a sense, I was being generous in saying it doesn't have subject matter jurisdiction, and that's based largely on the discussion in en route. So,
Thank you.
thank you. And unless the court has further questions, again, the city is conceding error. We offer that this was a void order and acknowledge that this court must reverse. Thank you very much.
We do have time remaining if you want to say.
Thank you, Your Honor. Just 2 quick points to clarify. Judge Lanzinger, to your question about the Caspian community control sanction, and yes, that would have absolutely been appropriate here had there been some previous order extending his community control, which there wasn't. And then the only other thing I'll say, Judge Carr, to your question about sort of the case law involving subject matter jurisdiction, I could easily see an opinion from the Supreme Court of Ohio or even, this court too, I think recently, I could easily see something that says, well, the trial court does have subject matter jurisdiction, generally speaking, over community control violations for the underlying criminal case, but here it improperly exercised its authority in finding that that Mr. Taylor had violated community control in this case. I do think that these are just 2 different ways of getting at the same point, or getting at the same end result. Here is that no matter what you call it, the trial court did lack the authority to do it here, but I could certainly see that maybe the technically correct way, based on what the Supreme Court of Ohio has been saying about subject matter jurisdiction, is that this is an authority problem, not strictly speaking a subject matter jurisdiction one. Thank you, Your Honors.
Thank you. And the court will take the matter under advisement and issue an opinion that will be sent to both sides and also released on the Supreme Court website electronically, so you can look there. And it's not very often that we have counsel for the state or the city and the defense working so carefully together to see that justice is done, and I appreciate that. I'm sure the rest of the bench appreciates that too. Thank you.